Hey everybody, Lieutenant PK here, and today I'm going to be talking about loitering and prowling. Just so you know up front, I'm not just going to be reading you the statute and ending the lesson. In fact, when it comes to loitering and prowling, the statute only tells you about 50% of what you need to know to make one of these cases. The other 50% comes from case law. And I'll tell you right now, some of that case law creates requirements for law enforcement that you would never know about if you were relying on the statute alone. Let's begin by looking at the statute itself. Florida Statute 856.021, loitering or prowling. Section 1 is the meat and potatoes of this statute. It is unlawful for any person to loiter or prowl in a place at a time or in a manner not usual for law-abiding individuals, under circumstances that warrant a justifiable and reasonable alarm or immediate concern for the safety of persons or property in the vicinity. I'll be paraphrasing some of these sections as we move on from this point because we're going to be talking about all of the elements in the next section of the lesson. So in section 2, it talks about some of the circumstances which you can consider when determining whether such alarm or immediate concern is warranted, such as the person flees upon the sight of law enforcement officer, refuses to identify themselves, or tries to conceal themselves or any object. This next section says that unless the person flees or there's some other circumstances that makes it impractical, you as a law enforcement officer, prior to making an arrest, are supposed to afford them the opportunity to dispel your alarm and identify themselves and explain why they're there. The statute goes on to say that no person shall be convicted of this if the law enforcement officer did not comply with that procedure, or if it appears at trial that the explanation given by the person is true, if believed by the officer at the time would have dispelled that alarm or immediate concern. And finally, any person found violating this particular statute commits a second-degree misdemeanor. As I mentioned at the beginning of the lesson, knowing the statute only tells you about 50% of what you need to know to make one of these cases. The other 50% is going to come from case law. So let's see what the courts are going to require from you to prove the person was guilty of loitering or prowling. The courts have determined that you're actually going to have to prove two elements to prove loitering or prowling. And if you look, these are both contained in section 1 of the statute, but the courts broke them into two. 1, the defendant loitered or prowled in a place at a time or in a manner not usual for law-abiding individuals. And 2, such loitering or prowling was under circumstances that warrant a justifiable and reasonable alarm or immediate concern for the safety of persons or property in the vicinity. Now keep in mind that this statute is a little unusual because with most statutes, you're trying to prove that the person already committed an offense. With loitering and prowling, you're trying to look towards future events. You're trying to predict that they're about to commit an offense, that they're creating a danger to the safety of persons and property in the area. And we accomplish that by looking at specific facts and circumstances and drawing rational inferences from those facts and circumstances. Let's look at a quick example of what I'm talking about. Let's say we have a guy hanging around the parking garage of an apartment building at 1:35 in the morning. Sure, that's suspicious. He's not doing anything else. But merely suspicious presence is not enough for the courts. We still haven't made our loitering and prowling yet. Let's add another factor. Our subject is looking in cars through the parking lot. Now, some officers will think, okay, that's enough. It shows he's about to break into a car. Well, a lot of the case law shows that just merely looking in the cars and walking around at this time of day may not be enough to prove loitering or prowling. Let's say our subject's wearing a dark jacket and gloves and it's a hot Florida night. That would add to those suspicions. Even more suspicious, he has socks on his hands instead of gloves. And when there's not a pandemic going on, another factor may be that the suspect covers or conceals his or her face. Just a reminder, we're proving two elements. The defendant loitered or prowled in a place at a time or in a manner not usual for law-abiding individuals. I think the circumstances we've already laid out show that. And 2, this can be the trickier one, it's under circumstances that warrant a justifiable and reasonable alarm or immediate concern for the safety of persons or property. When you look at some of the case law, sometimes just being there and looking in the cars but not taking any other action is not going to meet that second element. But let's say we have all of those factors and now the suspect is starting to try to open car doors on multiple cars. We definitely have a strong loitering or prowling charge because we can show both of those elements in our report. But we're not done with our investigation just yet. Remember section 2 of our statute? Unless the person flees or other circumstances make it impractical, you have to give them the opportunity to dispel your alarm, identify themselves, and explain why they're there. Now we're going to get into some more case law. Back in 1975, the Florida Supreme Court looked at this particular part of the loitering and prowling statute and said, clearly, an accused cannot be compelled to explain his presence and conduct without first being properly advised under Miranda standards. If the accused voluntarily explains his presence and such explanation dispels the alarm, no charge can be made. Since then, many of the lower courts in Florida have interpreted that to mean that a law enforcement officer has to advise the person of their Miranda rights prior to questioning them why they're there. That's not exactly what it says, but it's pretty much become the standard. So, to play it safe, you should always advise the person of their Miranda rights. That's not the only requirement that courts have made that doesn't appear in the statute. Here's another one. Only a police officer's own observations may be considered in determining whether probable cause existed to make a warrantless arrest. That means the courts will only be judging whether or not the defendant actually committed loitering and prowling based solely on the factors that you as a law enforcement officer saw when you arrived and what your fellow law enforcement officers saw. They won't go by what the witnesses said prior to your arrival or even the call that brought you to the scene. You can't use those factors to prove loitering and prowling. So let's say a homeowner says a guy dressed all in black is walking down the road at 2 o'clock in the morning, going driveway to driveway in his neighborhood, trying car door handles. But when you get there, the subject he described is merely standing by the road. Remember, mere presence alone, even being suspicious, is not enough to make the case. And none of the factors for loitering and prowling occurred in your presence, so you will not be able to make this charge. As you can imagine, this requirement from the courts makes making a loitering and prowling arrest extremely difficult. Here's another requirement from the court that makes making these cases difficult. The offense of loitering and prowling must be completed prior to any police action. What that means is the courts will only be looking at what officers observed and only up to the point that they made contact with the suspect, or in many cases when the suspect became aware of the officer's presence and, say, fled on foot and necessitated the officers taking some type of action. It will not be judged on what you find after that point. So let's say you make your arrest and you find a screwdriver and gloves and other items that would show, obviously, that this person was up to no good, though that will not be admitted in the loitering and prowling charge. And since none of this is mentioned in the Florida state statute at all, I thought I'd throw in a couple cases. Here's one from the 4th DCA out of 2014. We first find that the items found in the defendant's backpack after his arrest should not have been admitted or considered by the trial court because the offense of loitering and prowling must be completed prior to any police action. Here's one from the 5th DCA. We recognize that the possession of the 12-inch screwdriver gives support to a suspicion of imminent criminal activity after the fact. However, the offense of loitering and prowling must be completed prior to any police action. I could go on giving you more and more cases from all of the other DCAs, but I think you get the point. Now do you understand what I meant when I said if you only know the statute, you only know about 50% of what you need to know to make one of these cases? All right, let's do a quick review. There are 2 elements to loitering and prowling. Here's a summary of both. 1, loitering or prowling at a place, time, and manner not usual for law-abiding citizens. And 2, you have to show there's an immediate concern for the safety of persons and property in the area. Both of the elements must occur in the officer's presence, and you can also use the fellow officer rule. The offense of L&P must be committed prior to any police action. And our last one, Mirandize the suspect and give them a chance to identify themselves and dispel your alarm unless flight or other circumstances makes it impossible. Well, that's it for today. We covered a lot of material in there, so feel free to watch this video more than once. Stay safe.